I'm Sam Kemble with Workforce Delivery Inc. Today we are talking about why safety rules must be and be perceived as reasonable. Like many controls on safety-sensitive work sites, our preferred line of defense is to eliminate or completely control hazards through design and engineering. Administrative controls must mitigate residual threats that companies cannot, for lack of a better phrase, engineer out of the work process. Managerial measures include controls levered by training, policy, and procedures, and personal protective equipment requirements. Together, they are designed to motivate or encourage employee behavior to eliminate, mitigate, or control residual safety risk. We rely on rules and rule compliance for many reasons, including to protect employees' safety. To set and administer rules effectively, we pay heed and study the realm of human behavior. Many industrial safety-sensitive sites operate on a reasonably authoritative chain of command structure to organize and execute work. However, due to the often large geographic footprint of industrial sites, usually in dynamic, open environments exposed to changing factors, companies must rely heavily on autonomous rule compliance, which means that individuals follow the rules when not in the line of sight of one who directly supervises them. Thus, safety performance relies on the cultural norms and buy-in of teams working to keep each other safe. Individual compliance and peer enforcement rely on a hearts and minds approach or buy-in into the rule. This requires leaders to explain and inspire, rather than solely direct and instruct, safety leadership when setting and administering controls. Therefore, we need to be willing to get into the questions. Why is a rule reasonable? What prompted management to install the expectation? Why is it in my interest and my coworkers' interest to follow these rules? And what makes this rule reasonable? These are the types of questions that need to be embraced and explored with crews to achieve a hearts and minds buy-in. If our team does not understand why a rule is made or does not believe it is reasonable, things can go wrong. To illustrate, I'm going to reflect on one of my favorite courses at university. It was led by a quirky history professor who studied a phenomenon called jury nullification in early English common law. He referenced heavily Thomas Andrew Green's book, Verdict According to Conscience. During this time, England defined murder by statute. Hence, the courts were not authorized to find anything inconsistent with the statute's definition of murder. The crime of murder was described as a death where a human had contributed to that death. And if a court found that someone had committed murder, the automatic consequence was capital punishment. And within this construct, there was only one defense: self-defense. And self-defense was also very rigidly defined. The individual relying on the self-defense had to be smaller than the would-be attacker, had to be wielding a smaller weapon, or the individual that was fallen had to have been wielding a more deadly weapon than the individual relying on the self-defense. A person depending on the defense also needed to be unable to escape the would-be attacker. All of these things needed to be in place for a jury to find a person not guilty by self-defense. My professor and historian Thomas Andrew Green was appropriately suspicious as to how this may have been played out in real-life jury trials. They compared jury trials' findings of fact during that time frame against the facts issued by coroner's reports in the very same cases. They found discrepancies between the coroner reports and jury findings of facts. Case in point, one coroner report found that a husband walked into his home where he found his wife with another man. A struggle ensues. The husband used a knife to stab the man. The man dies. A jury in the same case found the following. The husband encounters a man outside of his home. The jury found that the man had an axe. The axe seems to have appeared out of nowhere. And the husband, while trapped against the edge of a cliff, which the cliff also appeared out of nowhere, was unable to escape. The jury then concluded the husband used the knife to defend himself against the man wielding an axe. In that case, the jury did not find that the rule was reasonable. The jury did not find the consequence suitable. Hence, rather than issue an unjust ruling leading to an unjust consequence, the jury searched for and found the facts required that would enable them to rule the individual not guilty by self-defense. So essentially, the jury nullified the unreasonable rule. Thomas Andrew Green refers to this as jury nullification. The same thing can happen to us if our workers do not believe that our rules are reasonable or reasonably administered. Leaders must continue to accept questions regarding why we do the things we do, invest in the effort to explain and inspire, because failing to do so may result in our safety rules being nullified out in the field when we are not looking. A prime example of this points to the Alberta construction industry's experience in administering the COAA Canadian model for providing a safe workplace, alcohol and drug guidelines and work rule. Earlier versions of this model relied upon almost exclusively peer and frontline supervisory administration of the rule in two basic scenarios. One, a relatively prescriptive post-incident testing rule, and two, a more subjective reasonable cause testing rule. Often, owners and safety representatives found 20 to 25% non-negative results arising from post-incident testing, a lagging indicator as an incident or near miss would already have occurred. So 1 in 5 or 1 in 4 safety incidents occurred concurrent to the presence of alcohol and drug levels higher than that allowed under the safety-based rule. The foregoing coincided with a low level of the frequency of peer or supervisor-initiated reasonable cause test, a control arguably more preventative than post-incident testing. Hence, the discretionary aspects of the safety rule were nullified. Upon further explanation, peer and frontline supervisors were reluctant to administer the rule for 3 key reasons. 1, discomfort in confronting one on their substance use, especially with the stigma attached to alcohol and drug use and abuse. 2, they did not feel the testing regime was fair in respect to the marijuana panel, which measures levels associated with use on personal time away from work. And 3, they did not believe the consequences associated with the positive test were fair for those who recreationally used marijuana. As a result, many employers who installed the Canadian model on their work sites had a significant portion of their work rule nullified by its workforce, drastically reducing the safety efficacy of the practice, which was its primary purpose in the first place. There are answers to the concerns of peer enforcers and frontline supervisors. However, in that case, leaders were not equipped to demonstrate the rule's reasonableness or appropriateness, and the rest was history. Supervisors and peers' reluctance to administer the reasonable cause portion of the Canadian model prompted owners to impose site access testing to fill the void in preventative controls regarding their alcohol and drug administrative rules. Workforce Delivery Inc. provides managers, supervisors, and leadership training to lead and hold space for these complicated questions. If you'd like to know more about those types of services, please have a look at our website at www.workforcedelivery.com. Thank you for your attention today. This is Sam Campbell. Good day.